Hello, and thank you for joining us today on the Ask Andrew Show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal of Feldstein Family Law Group. We have offices in Markham, Vaughan, Oakville, and Mississauga, and the entire firm practices exclusively in the area of family law. And today we're joined by special guest Bob Klotz, who's probably the foremost expert on the intersection of family law and bankruptcy law. I know I always call Bob when I have a problem that intersects with that. And without further ado, Bob, welcome to the show.
Thank you, Andrew. Looking forward to it.
And I must say, I love the background that you have behind you there. It adds a little bit of humor for what is otherwise not such a funny topic for people, family law and bankruptcy law. So I think it's a nice change.
I try not to take myself too seriously, but this is the closest I've been able to come to the look of my actual office. So it makes me feel very much at home.
Well, then let's hope it makes for a better show then.
Okay.
I'm going to get started by saying, what's the difference between bankruptcy and insolvency? Because I know the Act seems to have both words in it.
Yeah. It used to be called the Bankruptcy Act, and now it's the Bankruptcy and Insolvency Act. Bankruptcy, the distinction between the two is very similar to the distinction between married people and common law spouses. So when you're married, you actually have a certificate that says you're married. There's a government registry that says you're married. If you want to find out if people are married, you can look it up on the government registry. I've never done that, but it is a matter of public knowledge, or you can look in the court file and there's something that says these people are married. So you're either married or you're not. It's a bright line. And you know the bright line generally, and so does the world. So in bankruptcy, when you're bankrupt, it means you have filed under the Bankruptcy and Insolvency Act, and you've filed for bankruptcy. You can file under a few things, but bankruptcy is the primary one for people. The other is proposals, and perhaps we'll get to that. But you've actually filed for bankruptcy. All your property is vested in the trustee, and you're under some limitations. You can't really own property or acquire property while you're bankrupt, that sort of thing. Insolvency is like common law spouses. How do you know if someone is a common law spouse? Well, there's nowhere you can look it up. You may not even know, and certainly the public may not even know. They may think you are, but you're not really, or they may think you're not, but you really are. It's a matter of, it's a question of fact. And in fact, I think it's the Milotovich file, the Supreme Court of Canada file, that gives all these different factors, and they give 7 kinds of factors, each with sub-factors, or about 10 sub-factors for each one. And you're supposed to go through this and check off the boxes and think, well, they've got that box and that box, therefore they're probably common law. It's the same with insolvency. It's not a status, it's a condition. And whether you have that condition depends on the circumstances. There's generally the basic definition is your assets are less than your liabilities. But many people have assets that are less than their liabilities, and they're not insolvent because they can pay all their debts as they come in. For example, most lawyers could be classified as insolvent because generally they don't own their house, they give it to their spouse, and their big asset is their income. So lawyers can pay their expenses. They don't claim that they're insolvent. No one would think they're insolvent, but under some definitions of insolvency, namely assets versus liabilities, they may have more liabilities than assets. So there's a definition section somewhere. It's actually in the BIA, and the primary definitions are your assets are less than your liabilities. That's sometimes called the balance sheet test. And the other is you can't pay your debts generally as they come due. And you may be loaded with assets, but if you can't get your hands on them and your creditors come calling and you say, sorry, I can't pay you for a year because I don't get that asset until a year goes by, you are insolvent, even though you're loaded.
Yep.
You have to be insolvent to go bankrupt. Some people go bankrupt even when they are solvent. And for those people, if you're a creditor and there's some problem, they're scoundrels, you can apply to annul their bankruptcy because they're not insolvent. And that comes into play in family law when people are malicious and they want to use the B word, the bankruptcy bomb, to blow up a family law proceeding. whereas really they have a lot of assets and no one's pressing. So those people do go bankrupt when they are solvent, and one of the remedies is you can ask to set aside their bankruptcy. So that's the interplay between bankruptcy and insolvency.
Okay, I'm going to lead into a couple things that you said there. Number one, you said the bankruptcy bomb in family law. Can you explain what you mean by that?
Yeah. Bankruptcy has, in many cases, a dramatic impact on the family law case. First of all, in Ontario, by the way, is your viewership is all over the place, right? All over Canada, or mostly Ontario?
But we're primarily Ontario.
Okay, well, I'll restrict this to Ontario because we have an equalization system. An equalization claim in family law is the way assets are divided, and they're not actually divided themselves. There's a calculation that you throw in, and it's all set out in the Family Law Act. You add in all your assets, and you subtract all your liabilities on the date of separation. And then if you came into the marriage with assets, you subtract that. So each spouse has a net family property, which is how much the value has increased during the marriage. And if one spouse's increase is 100,000 and the other's is 50,000, then the difference is 50,000. The spouse with more pays 25,000 to the spouse with less, and they both come out with $75,000. That's equalization. The problem is equalization is a debt. And one of the features of bankruptcy is it stops all debt actions. You can't enforce debts. So as soon as someone files for bankruptcy in a family law claim, the equalization claim cannot be prosecuted in the family law claim. It's stayed, it's stopped. The only way you can realize on it is by filing a claim in the bankruptcy and getting 2% or whatever all the other creditors get. There's special rules for pensions, and we can get to that in the family law setting, but that's one of the impacts. The other is that the equalization claim gets wiped out by the discharge in bankruptcy. It gets stayed during the bankruptcy, which is either 9 or 21 months usually. And then when the discharge comes, the debt is wiped out. And so the spouse who's claiming a division of assets has a real problem there. The family law property action is stayed. The second problem with bankruptcy is professionals. Everyone knows who's been through it knows the cost of hiring a lawyer and having a lawyer go through the litigation. Litigation is extremely expensive, unfortunately. And if there's a bankruptcy on top of it, the sad fact is that most family lawyers don't know a whole lot about bankruptcy, fortunately or unfortunately. And there's a systemic reason for that. How many of their files have a bankruptcy in them? Very few. And so they're not enough for them to become familiar with it. So the family lawyer may have to get a bankruptcy lawyer involved. Now, let's say the poor wife has 2 lawyers to pay with after-tax dollars. The trustee is charging for his services. It's not as much usually as a lawyer, but it can be hefty. And the trustee in a complicated case may have to hire a bankruptcy lawyer. So the wife has 2 lawyers. There are 2 professionals, the trustee and the trustee's lawyer. Then the husband has a lawyer. He may have a bankruptcy lawyer too. All of these people are converging, all with fees that go by the hour. So it can be ruinous even if you win. That's the problem.
Well, you said some interesting things there because number one, the equalization payment gets stayed. And it's interesting because I can think back to, I've seen this one happen a few times where one person starts a business and they put the house in the other spouse's name, who's a T4 employee. They start a business, the business fails. They personally guaranteed a whole whack of debt to the bank.
Yep.
So then the bank comes calling and the person discusses it with the wife and they both agree, I need to file for bankruptcy. Okay.
Right.
And then 6 months later, they separate. And this person's going through a bankruptcy, but the house is in the wife's name and say that's the only asset.
Right.
What happens to that person's equalization claim?
Okay.
In the bank?
Only debts that arise before the date of bankruptcy are wiped out. So they separate 6 months after bankruptcy. The husband at that point has 0 debts. He has zero assets except for his pension.
And when I say bankruptcy, I mean filing for bankruptcy. Not
Yes, that's the only way you can go bankrupt. Well, you can be petitioned into bankruptcy, but yeah. So the husband has his pension, the wife has her assets, she may have some liabilities, and they equalize them. It's not really a problem.
Now,
The only difference is, the only artificiality is the husband has no debts, and if they'd separated just before his bankruptcy, he would have been totally debt loaded with his millions of dollars that he'd guaranteed to the bank.
And what would happen to his equalization claim if he
his equalization claim goes to his trustee if he hasn't settled it yet. The law is horrible in that area, and I can talk about that. I can talk about anything actually at length, but I'll let you ask questions before I go off on tangents.
But what would happen if they separate and he files for, or I should reframe that. Let's take the opposite situation. It's not 6 months later. It's she separates from him and now he files for bankruptcy a week or two later. What happens to his equalization claim? I heard you say that then goes to the trustee in bankruptcy. And what does the trustee in bankruptcy then do with the equalization claim?
Okay, well, this is a subject that I've been very concerned about for quite a while. And in fact, I wrote an article a year or two ago on this and explained how the law is totally unjust. The bankruptcy trustee generally acquires the right to any proceeds of the equalization claim, along with any property the husband has that's non-exempt. The case law currently says that the trustee can't start an equalization claim because it's personal to the spouse, but the trustee can settle it, or the trustee can sell it to the other spouse. So what you have is a trustee with an asset that he or she cannot realize except through negotiation, because the trustee can't start the claim. So what does the trustee do? He says to the two spouses, look, I'll take the best offer. The husband in this case has gone bankrupt. He has no properties. He's the one that has to prosecute the equalization claim and pay for that to happen. The wife has all the assets, in this case, the house. She's not bankrupt. She can get credit, which the husband can't do. She can make a bigger offer. She can make an offer 10 times the size of the bankrupt's offer. So she's generally going to win that. And what kind of offer does she make that the trustee will accept? Well, I have cases where the trustee will accept any offer. In one case that I've written about, my client had a very strong equalization claim for $800,000 because the wife owned her pension, she owned the house alone, and he had just gone bankrupt. He had $3 million of debts. And ultimately, the trustee put the equalization claim up for auction between the two of them. He couldn't bid. He had no money. She bid $25,000 on an $800,000 equalization claim, and the trustee accepted it. And the reason is the trustee in these cases is primarily concerned about getting money for his or her fees. That's I suppose, not very generous for the trustees. But as a practical matter, from what I've seen, the trustee is interested in getting paid his or her fees rather than getting a windfall for the creditors. The settlement generally is not enough to generate any realistic dividends to the creditors, so the bankrupt gets royally shafted. He had a claim that he needed for his retirement. These people were both in their 50s. He had nothing for the rest of his living, years. She had a huge teacher's pension, and he loses his right to support himself with a pension or half a pension, and buy a house or rent a property with half of the value of the home. She gets to keep everything, and it's quite unjust. I don't like it.
Okay.
So one should strive not to get into that position, namely settle before bankruptcy. Spouses should pause before they go bankrupt if they're involved in a matrimonial claim. And if the claim is actually being commenced, then the trustee gets to take over the husband's claim. He gets to litigate it, which he'll never do for reasons that I elaborate at length in the article I've referred to, or else he'll settle. So it's the same dynamic.
How often does the trustee do nothing with the claim And then if the trustee does nothing with the claim and the bankrupt is discharged in 18 to 21 months, can the bankrupt then make the claim at that point?
You would think, but the answer is no, but. One of the pillars of bankruptcy law is that you don't get back any of your assets if you're the bankrupt person unless they are actually transferred to you by the trustee. And how do you transfer a right to sue? You make an assignment, which is basically a simple document saying, I hereby give the right to equalization back to the bankrupt. And it's in writing and it's signed by the trustee. That's all you need to get the status after you're out of bankruptcy to continue. But the tactics are really quite sharp in this. If the wife in this case makes an offer to the trustee, then the trustee has to try to get the best value for the asset, can't just give it back. And so in the case that I've been involved in, the trustee had said, I don't want to have anything to do with this. You take care of your family affairs. The wife's lawyer, who is a colleague that I work with or work against, wrote a letter to the trustee saying, we're prepared to offer something to buy this equalization claim. Please contact us. And so the trustee did this auction. He was not interested in destroying anyone's life until he got this, proposal that the wife wanted to buy the claim. And the purpose of that was to prevent this guy from getting an assignment after he was discharged.
So let me ask you this then. If I'm the bankrupt and my mother or father has money or my friend has money, can they go buy the claim and then sell it to me? And if I'm, say, the husband who went bankrupt, am I then able to advance that claim because it's a personal right to me?
That one hasn't been litigated, that question. The only case I've seen in that vein is one up in, I believe it was Thunder Bay, where the wife had gone bankrupt, and then just before something or other, instead of getting an equalization claim of $100,000, which would have given her enough money to pay her lawyers, she entered into an agreement to get nothing. And the lawyers were upset about it, and then she went bankrupt. And the lawyers were upset about that because the bankruptcy was designed to prevent them from getting paid from her equalization claim. I mean, presumably that it would have been an under the table deal where she'd get some money later, or her support would be increased, something like that. And so the court decided that the law firm could take over the litigation for equalization. The judge settled it for a certain fixed amount that the law firm was prepared to accept and the husband was prepared to accept. And that money all went to the lawyers. So they didn't actually have to jump into the case, but they were held to be entitled to the equalization claim and therefore could proceed to a settled amount which they would get. That's the only case I've ever seen where a non-spouse has been allowed to participate. I mean, it's one thing, I don't think a creditor with a judgment can garnish the right to claim equalization.
See, I was thinking of it more, the mother to the father, let's say the father who went bankrupt would buy the claim from the trustee because they could outbid perhaps the other spouse.
Sure.
And then after that spouse is discharged, it gets transferred back to the spouse who has the personal right to litigate.
It's definitely an idea. It's something that, frankly, I consider. And if the circumstances were right, I'd probably do it. But if I were in the wife's shoes, I would object.
Well, so would I.
She doesn't want a stranger to the relationship getting involved in an intimate aspect of the relationship, namely money.
You talked about pensions having special rules for bankruptcy. I'm going to go there in a minute, but I also wanted to understand, how are trust claims impacted by bankruptcy? Because you have a 10-year limitation period to advance a trust claim. So I think of the scenario that you said.
Well, against land.
Well, yes. Yeah, so I'm thinking of most people's largest asset these days is their home.
Yeah.
You have that situation where you have a lawyer. Let's say that lawyer goes bankrupt, but they're the ones who put all the money into the matrimonial home that's in their former spouse's name, which would mean if I went to court and argued a resulting trust because they put all the money down, I would win on that. And that would have a 10-year limitation period. So I'm not worried about the bankruptcy coming to completion, but how would that trust claim be impacted by virtue of the bankruptcy?
Okay. Well, you as the bankrupt or the ex-bankrupt now discharged can't claim a trust that would have vested in the trustee in bankruptcy. The trustee may never have known about the trust claim, in which case you have not fulfilled your bankruptcy duties by advising him. If you start a claim, the wife in that case would say, no, the trustee has whatever you have, a resulting trust, which I don't think you have anyway, but if anyone has it, it's your trustee. Where is the assignment of that right to you? Now, if the guy gets an assignment, he's okay. But if he doesn't, then the trustee will settle it a little bit more favorably than equalization claims are settled, but trustees are amenable to settlement. They're easier to settle with. That's a resulting trust. Constructive trust is much more difficult because they require discretion of a judge. And many judges are sick at the idea that someone goes bankrupt, wipes out all the creditors, doesn't do anything during the bankruptcy, waits until everything is wiped out, and then shares all his claim, I guess, with his wife. So the creditors get nothing, the bankrupt gets everything. And many judges do not like to exercise their discretion for people who do that, well, especially if they haven't told their trustee about the trust.
I've seen ones where the person went bankrupt and claims a trust claim, but they claim it 5 or 6 years later, saying that 10 years ago, I paid for
Correct.
that house. And 5 years after their discharge, they claim the trust claim. Do you think it has an impact in that scenario?
Generally, there isn't a whole lot of sympathy for someone who does that on the judicial level. They like creditors being paid. I mean, they like protecting spouses and kids a lot, but they're not fond of creditors being shafted. And so you as a lawyer, if you're acting for the husband, have to deal with that. And there's a way to deal with it. You need to get an assignment from the trustee. So you get an assignment that gives the trustee a certain percentage of the equalization claim. In other words, you buy the right to make that claim from the trustee on the understanding that the trustee will get a specified piece of any net proceeds of the litigation after costs and so on. And then you can go to the judge and say, look, I have this claim. The trustee's happy with me pursuing this claim. Trustee knows about it, and the trustee's going to get a piece of it. And this is also the only way that the creditors are actually going to get some money. So all of a sudden, the husband has virtue, justice, and the American way on his side, which is what you want when you're in litigation. You want to be the good guy.
I get that. And you talked about pensions. How does the bankruptcy impact the pension, and how does it impact it from a family law perspective?
Okay, well, when you go bankrupt, you're entitled to keep your exempt assets. And that means a pension. It means, certainly for the past 15 years, an RRSP or a RIF or any product like that. And a few other things, but that's generally the kind of asset that has the most value in this context. I mean, in other provinces like Manitoba, they have farm exemptions and they have residence exemptions. And that goes up to, I think, 40,000 per spouse in Saskatchewan. But here in Ontario, we don't have a residence exemption. And I should put a little sort of star there. There is a piece of legislation that says there's an exemption for $10,000 against anyone realizing on the home if the equity's under $10,000. And some people think that that is an exemption, but it's not. It just allows the bankrupt to stay, and no creditor can boot them out that's not going to get any return from it. So it's not really an exemption. But in any event, the pension is exempt. So the wife has an equalization claim, and it's basically for half the pension in many cases, because neither of them has any assets except this pension. This is simplifying it all down. Neither has any assets or any debts. The husband has this pension, and so the wife's equalization claim is basically for half the pension, because that will equalize what they both have since the date of marriage. The problem is that her equalization claim is stopped by the bankruptcy, and then it's wiped out by the discharge. So I've had a number of people, including family lawyers, who have said to themselves, well, look, the bankruptcy doesn't touch the pension. I'm just going to wait until all this bankruptcy garbage is out of the way, and then we'll carry on with the equalization claim. And that is fatal, the equalization claim dies when the bankrupt's discharged. So I developed a fix, at least I call it a fix to a badly designed structure. The Family Law Act is badly designed in this respect. And the fix is you go to court and you ask as a spouse for the stay to be lifted so you can proceed to get an equalization claim, one of the remedies of which is to actually divide the pension in half or whatever the proper proportion is. And that allows you to escape the problem of the discharge. The standard order I use is the wife or the husband can do this notwithstanding the bankrupt's discharge. So the problem is solved. And it's a cheap order. It's always granted now that the case law has been built up. So all it requires is that the family lawyers, there's no way spouses are going to know about this stuff. It's counterintuitive that the rules of bankruptcy would wipe out a pension claim when the creditors don't get it, the trustee doesn't care about it. It's only the wife. So the family lawyers have to know about it. They have to know about this red flag that when there's an equalization claim against an exempt asset, pension or RRSP, you have to get this funny little order, a lift stay order is sometimes what we call it, and that will solve your problem. And I wrote an article quite some time ago about how a family lawyer could get this kind of order without hiring a bankruptcy lawyer. My career arc, just for your information, is to isolate the profitable areas of practice and to gradually eliminate them one by one. So as a result of this article, I do not get retained to get this kind of order anymore. And I'm fine with it. I don't like people having to pay my fee for something that should be in the legislation. And I've been trying to get the legislation changed so that no one has to get this kind of order. There's sort of a low-grade lobbying campaign that I'm starting to rank up that would get the Bankruptcy Act changed so that that doesn't have to happen, because it can lead to injustice if the family lawyers miss the red flag, which unfortunately they do because they're not too familiar with bankruptcy. And despite the lecturing that I've done around the province and around the country about this, my experience is that family lawyers do not retain what I tell them about the Bankruptcy and Insolvency Act and the interrelation between the two, because it's complicated and it doesn't come up in their practices enough for them to be familiar with it. They much prefer either to have an article to read or a telephone nearby so they can call a bankruptcy lawyer who has some expertise in family law for advice. So there's still negligence claims and there's still people that are losing their claim against a pensioner and RSP, unfortunately, because of a defect in the law.
Well, I know I've brought those stays that you mentioned, and I know I've called you many times over the years with questions because, like most family law practitioners, we don't deal, you hit it right on the nose, we don't deal with it very often, and it's confusing and it's complex, which also leads to my next questions is, what happens to child and spousal support when someone files for bankruptcy?
Okay. Well, this is a question that's very personal to me because I proposed a change to add a new support enforcement remedy to the Bankruptcy and Insolvency Act back in, I think, 93, and it was rejected by the government. So I had to start a national lobbying campaign, which I did. And eventually it got put into the amending legislation. And so now we have a special bankruptcy remedy for support. So support used to be treated in this way. If someone went bankrupt, the support was not wiped out, and that's still the case. But it couldn't be a provable claim in the bankruptcy. And a provable claim is one that gets to share in whatever proceeds, they're called dividends, the bankruptcy trustee ultimately distributes when all the assets are collected and the creditors get their pro rata share. And usually, by the way, the pro rata share is 0% in most bankruptcies. I would say about 90% of bankruptcies, creditors get nothing. Frankly, I haven't looked up recent statistics, but it was, I think, even higher than that traditionally. But in family law, bankruptcy family law cases, there are usually assets there. And so the wife would be told by the trustee, don't worry, your claim survives, you're not affected by the bankruptcy. But meanwhile, that house is going to be sold and all of the proceeds are going to be distributed among all the other creditors except for you. And that seemed wrong. I mean, support is considered one of the higher obligations, not a lower obligation or a zero obligation. So we managed to change that. And now it's a bit more complicated. The reason it's more complicated is because the government decided to use obscure bankruptcy language in 4 different sections, all separated by about 30 sections. So it's scattered around the Bankruptcy and Insolvency Act. And it's somewhat incomprehensible. And so it can't be accessed easily by the spouses themselves. It can be understood by family lawyers. So the first change is there's a section that has always been in the Bankruptcy and Insolvency Act that says support never gets extinguished by a discharge. And that's section 178. That stays. And it's defined as support under a separation agreement or a court order made before the date of bankruptcy. That is a provable claim. There's a section that says if there is a support order or a separation agreement that was made when the spouses live apart before the date of bankruptcy, it's a provable claim. So that underscores that point. And that's a big change. Now, all provable claims get stayed or stopped by the bankruptcy, but support should not get stayed or stopped. So there's another section, 69.42, I think, that says a claim that falls under that category of support where there's an order or agreement, it's before the bankruptcy and it's while the spouse were separated, that does not get stopped by the bankruptcy. You can continue to enforce that, except for property that's gone to the trustee, like the house that goes automatically to the trustee, or against surplus income that the bankrupt might have to pay to the trustee. Anyone who goes bankrupt, if they make more or significantly more than I'll call it the poverty line, they have to pay half the difference after taking into account any special circumstances. And so the trustee grabs that. The wife, let's say, who's owed support, can't go after that. Otherwise, she can go after the exempt assets, the excess income, if there's any there. That's basically a tax, tax reimbursements, tax repayments, overpayments of tax. And there are a few other things that the wife can pursue. So there's also one final provision that gives support better status than almost all of the other unsecured creditors, puts her first in the saddle instead of not even having a saddle. And that's section 136. And it says, if the wife has support claims of the nature I've described, then she gets priority. When the trustee comes to divvy up the assets and give it to creditors, she gets priority for any pre-bankruptcy lump sum in that order or agreement, and for 12 months, 1 year's worth of periodic payments that are in the agreement or the order. Now, this isn't in first position, which I said, that's a simplification. It's actually in 7th position, but a few of those positions never arise. They're related to corporations, or they're just, I've never seen the other ones. Right. What has priority over a spouse with support claims in this category are 3 things. First of all, the costs of burying the dead body and administering the estate if the bankrupt has died. This is what the common law does too if there's no bankruptcy. The creditors don't get a penny until the funeral expenses and the testamentary expenses are paid. So that's straight from the common law. The second one is the trustee's fees and the trustee's legal fees. And that's a huge item. If the spouse, the surviving spouse, the wife, let's say, actually, no, he's still alive. If the wife has to fight the trustee over some asset, trustee's costs build up. He gets to take that money out of the estate ahead of the wife. And so what she gets dwindles simply because she's fighting. Even if she wins, she loses because she has to pay her own lawyer. The trustee pays his own lawyer, and the trustee pays himself. And the trustee's costs, they go out first. And the wife may be left with nothing, even though she's won a particular battle. I'm involved in one of those horrible cases right now. We're in the right, but the trustee is fighting like crazy. and the legal fees are skyrocketing. And there's a huge amount of money in the estate because the guy was barely insolvent. There may be nothing left by the time we're done. So it's a real tactical problem. Anyway, I've lost my place.
Well, we're actually out of time, and I found that to be a fascinating discussion. I learned a lot. I wanted to thank you for being on the show today, Bob. It was a pleasure having you, and I really appreciate you sharing your knowledge and experience. The next Ask Andrew show is August 23rd at 12 noon. If you have any requests or ideas for future shows, please email them to us at info@feldsteinfamilylaw.com. And thank you for watching.
Okay, well, thank you, Andrew. I must say, I'm just getting started. So it's been a pleasure.
Thank you.
Bye-bye.